Welcome to Just Verdicts with your host, Brendan Lupetin, a podcast dedicated to the pursuit of just verdicts for just cases. Join us for in-depth interviews and discussions of cutting-edge trial strategies that will give you the keys to conquering the courtroom. Produced and powered by LawPods.
So welcome to Just Verdicts. I'm your host, Brendan Lupetin, and today I'm joined by Katie Bertram and Kieran Murphy, and I'm laughing to myself starting this off a little bit because this is about our 9th iteration of trying to get the podcast going today. So Katie and Kieran, thank you so much for bearing with me today and sticking it out through all of our tech issues. So thanks for being here.
Well, thank you for having us. We're delighted to be here with you today, even if it takes 6 times. It's all good.
Yeah, thanks for inviting us on, Brendan.
Yeah, absolutely. And I'll say maybe that's actually a good thing because, while we were trying to get all organized, let's take a little rewind here. So Katie and Kieran are from the law firm of Bertram and Murphy, and you're based predominantly out of DC, right?
Yes.
Okay. And so I'm learning from the two of you, and this is very reminiscent of sort of a little bit of my backstory, that the two of you met in part because of sort of your love for trial strategy and nerding out about whatever the current stuff out there. And over the last, 15 years, there's just been such an explosion of great trial strategy out there. So I think it's really cool because that's very much aligned with me and a lot of my friends out here. I was telling you, Katie, that, Veronica Richards, for instance,
Yes.
started our affectionate reptile group out here that, has blossomed into a similar thing. But I'd love to hear more about, so the two of your origin story. And then, what are your biggest trial influences over time and then presently? Like, what are you really loving the most right now?
I would say that background-wise, the most influential thing for me has been a combination of David Ball and his partner Artemis. And then I was really, really fortunate to be able to go out and see Rodney Jew on 6 or 7 cases over the course of about 4 or 5 years before COVID. And Amy Hall was with him doing amazing graphics and exhibits at that point. And so I think those things, along with, I really connect with Mark Mandel too. I think some of his stuff is incredibly helpful. So those are the things that I have really influenced me as a trial lawyer personally. And that is how Kieran and I got together because we just both love learning about those things and reading and talking about them and strategizing. And so we were just sort of doing that as local lawyers, looking at different venues and judges and cases and how to do them. And that's how we got to be friends. And then that's how we ended up becoming law partners. So it was really just nerding out about the law.
Awesome. Kieran, how about you, man? What have been some of your, whether it's books, CLEs, presenters, have been, the people that have really connected the most with you over time?
Well, I think before I get into background, the person that's been the most influential for me has been my law partner, Katie Bertram. The reason that we became close is she actually reached out to me when somebody asked for help with an audit trail issue on some list server. She reached out to me. I had not met her before. We became very close, but she became somebody that I went to with questions all the time before we worked together. And her style is just it resonates with me a lot because it's so much about credibility and authenticity and being the most prepared lawyer in the room. So I think without a doubt, she's been the most influential for me. So while it's very flattering that she refers to me and I am her law partner, I always see her as both a partner and a mentor. It's been the best privilege of my career. But where it started, my love for trial practice was I had the privilege of clerking for a trial judge in Prince George's County, Maryland, which is right outside of DC. And it's one of, if not the busiest trial court in the state of Maryland. And the judge I clerked for was Judge John Davey, who unfortunately passed away recently. But I learned a lot from him about what does and doesn't work in a courtroom. And I got to see a lot of amazing trial lawyers during that year clerking. And I would always get in early and leave late because I would do my substantive work early in the morning and stay late to do stuff because I would just sit in and watch every trial I could. And I probably saw somewhere between I've never sat down and counted them, but probably between 30 and 45, 50 jury trials that year, bench trials, all kinds of things. And I learned a lot about what does and doesn't make a good trial lawyer, what does and doesn't resonate with a jury. And that was really impactful for me. And then for a couple of years after my clerkship, I worked at a small firm that did mostly high-end divorce litigation and custody litigation outside of DC. And those types of cases get tried a lot, not to juries, but to judges. And the lawyers I worked with, Paul and Randy and Maureen and Dan, they're just huge believers in the idea that you have to try cases when they have to be tried. You don't fold, you don't, bend over backwards to avoid going to court. And that kind of instilled in me a trial lawyer mindset that fortunately Katie shares. But I always wanted to do complex civil litigation. So after I worked with Paul and Maureen and Randy and learned a lot from them, I worked at a firm that did a lot of birth injury litigation, very good firm based out of Baltimore. Worked there for several years. I became very close with Katie and a lot of other lawyers locally during that time too. And so, yeah, I mean, my relationship with Katie happened very organically, but it's because we both have a love for trial practice and for the law, and we both have a similar philosophy, most of which I've been fortunate to learn from Katie. So it's been great. Other people, I'm a big fan of Rick Friedman. I really like Pat Malone. The whole rules of the road concept has always resonated with me because I'm a stereotypical firstborn child and I'm a big rules follower. And so I think it helps to have a good framework in place. And we talked about this earlier, Brendan and Katie, that, you take a little bit from all of these various trial strategies. Most of what I do is stuff Katie has taught me, though. That's overarching for me. And to the extent we incorporate other things, it's things that we've learned and that work for our style.
So that was a lovely homage to your partner and mentor. No, it was really sweet. I mean, that's great. And I think obviously speaks volumes about you, Katie. But Kieran, I think that was also really interesting, I think, blueprint that a lot of younger attorneys that have an interest in becoming trial lawyers could learn from your path in the sense of, I agree with you. I think getting to spend time in court, even if you're not practicing, but just getting the feel for like those dead silences, the awkward stuff, the things where people lose credibility and so forth was probably invaluable to you. And I know it's probably difficult to think back on that, but having done that, clerked and really focused on, I just want to immerse myself and see what feels right and what doesn't feel right. What do you kind of like, what were some of the biggest takeaways from you? That you started to see like, okay, I think this is good and this is bad, or things to watch out for?
The two biggest takeaways for me from my clerkship were the most prepared lawyer almost always prevails, even when it seems like the facts might be against them. And I just remember seeing a lot of cases where we'd go into a trial or even a motions hearing, and I, as the law clerk, would review the complaint, right? Because I'm getting the whole docket. So I would always review everything from the complaint all the way through, whether it was to the jury instructions, if it was trial, or to the disputed motion. And there were a lot of cases where I thought, oh, well, I mean, this seems like it's a real uphill battle. But you'd see a lawyer come in and just be so prepared, know the case law, know the rules, know the facts of the case, and be able to frame them in a way. This goes back to what Katie said. I'm also a big fan of Mark Mandel. And Katie is so good at framing facts in our cases in a way that I think a lot of lawyers tend to run away from them. And that's what I learned early in my career is you can take facts that are perceived as bad, and if you frame them and put them into the context of the case, that to me was a huge takeaway as a really young lawyer, that there's no such thing as a truly bad facts. They're just facts to be framed. And that it's important to always be truthful fully with the judge and jury, because they will give you grace if something bad happened or if there's a fact you need to address, but they won't give you grace if you get caught hiding or lying. And then the other thing was just, I saw a lot of lawyers, this came up more frequently in criminal cases, that would engage in sort of the type of lawyering we see on TV, a lot of yelling and finger wagging at the jury and getting really aggressive with witnesses, probably unnecessarily. And I never saw that work. I mean, I remember cases where a defense lawyer would get up and yell at the jury. And again, most of what I saw was criminal trials, which was great for teaching the evidence. not a lot of civil stuff. I didn't see civil stuff, but not as much as the criminal. But I remember one defense lawyer doing that, getting up and just yelling at the jury. I remember a prosecutor doing it in a rebuttal argument. And it was a case where, unfortunately, this gentleman had been convicted, but the case had been sent back on appeal because of issues related to voir dire. And then he was acquitted in his second retrial. And I took away from that one a lot because the defense lawyer was very polished, very professional. She was an excellent attorney, one of the best I saw that whole year. And the prosecutor seemed to be relying a lot on just the evidence was very strong for the prosecution, but it was a lot of just over the top bombastic behavior. I saw a lot of that from various lawyers. I took away that it's way better to be prepared and tactful than to engage in, rhetoric and bombast. The jury gets it. And I think if you treat them with respect, and you respect their intelligence, that's something that's always come away with me. And again, something that Katie does very well, and something that being in court with her has reminded me of that, because we don't get to try cases as often doing complex med mal. We try maybe 1-2 cases a year. And it's a great reminder when you go into court to see that done over and over again successfully. And that's something that we both do. But again, it's something Katie has done for a much longer period of her career. And it's just sort of a testament to those principles I learned as a young lawyer right out of law school.
Katie, you seem to have a very humble response to, all of Kieran's praise. And I can just tell it.
But it's hard for me to listen to
it. but from your perspective, Katie,
I'm just pretty basic, really. I think he's giving me a lot of credit. But
no, I'm sure it's very well deserved. But from your vantage point, Katie, whether it was for Kieran or other young lawyers, I mean, at this point in your career, are there, like some core principles that you think from what you've learned in all of your practice and all of the cases that you've tried that you think are just like those sort of like most critical? Like you can debate about different things and there might be different, stylistic issues, but what are the cores for you that are critical for successful trial practice?
So my number one that I mentor a fair number of young women trial lawyers, or I try to, because I think it's really important. We don't have all the same examples that guys do. We just don't have as many, right, that are out there that have been successful. So I would say it sounds so corny, but just to find who you are and feel comfortable with who you are, because I think I spent 20 years trying to be everybody else, and people know that. So that's the number one thing, that you're fine. Whoever you are, you're fine. And just be that. And then I would say, for us anyway, there's all this pressure with these huge trials to try to convince the jury. You're not going to convince a jury. Our job is different. Our job is to frame the facts in a way that they can understand it. And that's what we do. So you have to trust them. It can't be just BS like I'm saying I trust you. No. You have to trust these people to get to the right conclusion. And the way I can trust them is that we've done focus groups at various points in the case. And they don't have to be expensive focus groups, but we've done focus groups so we know what regular people think and how to frame it. And to me, that's the most important thing. And Kieran's heard this 1,000 times. So we cannot tell them what to think. Maybe at the very end in rebuttal, I do it sometimes when I get on my high horse. But for the most part, not my job. And if you do it, people hate it. So we can lead them to the water and we can make the water look really attractive. But that's as much as we should be doing. And the minute we step over, and it's so easy as advocates to step over, the minute we step over that line, we lose in my brain. So, you might come hear my opening and think, well, I don't know how she got $25 million for saying that. But it's because I once had a federal judge, a kind of famous federal judge, pull me up halfway through the trial. Ms. Bertram, come up here, and I went up there. It was a very complex case. and he wouldn't let you in this federal court in the Eastern District of Virginia. You can't leave the podium, so you can't use your hands, you can't use anything. And I was losing my mind, right? And because I'm a walker around and doer, and he called me up and he said, "Ms. Bertram, were you a teacher in your former life?" And I said, "Yeah." And he said, "Because you're driving me crazy. And you need to stand at the podium and stop pointing." And I said, "Your Honor." And he said, "My wife's a teacher too. And you remind me of my wife." And I thought, even though he's screaming at me, that's right. Like, that's it. That's my job. My job is to help you, the jurors, see, understand, and then do your job. And that's what I'm passionate about. So if you can get there, however you want to do it, whatever you want to wear, whatever, that's our job. And so I'm also lucky because Kieran's really smart and he can worry about all the legal stuff in the trial. So in the, you're trying two cases at once, right? You're trying a case of facts to the jury, but you're also trying all the legal BS we have to do. So thank goodness I was doing this all by myself, but now I've got somebody else to help me with the legal stuff. I can keep it in my head, but these two parallel tracks are so different. So staying in tune with what real people think and staying at 60,000 feet and not getting down into the muddy, gritty stuff that we also have to think about is really important. Because these people are going to have your case for 2 weeks. That's it. That's all. Not the 2.5 years, not all the crap that you know. And I think that's really important to remember to just try to be a regular person. The focus groups help me keep that, right? When you're in the weeds for the 2 years, battling every single legal issue, worrying about motions in limine, trying to get evidence in, yes, you have to do all that. But more importantly, you have to be able to stay at where these poor jurors are when they're hearing for the first time, what's angiosarcoma? What the heck is that? And what's going to happen to this guy? And so that's, to me, the thing you have to do is staying at that level. And then I will say the other thing that really helped me is, I forgot, Pat Malone's book on cross, and it may have just been the timing of when I read it.
What, the Fearless Cross-Examiner,
yes,
that one? Yeah.
Yes, that book really helped me think way differently about cross. And so after that, I decided, you know what? Cross isn't about me either. And I don't care if I have to get bloodied up a little bit. I don't care. I'm going to do my cross in a different way and not let my ego get in the way and try to really show what this expert is about and what a jerky is, or what, why his, and if I get hit a couple times and I take on water, that's okay. Because in the end, I'm going to prove my point through the jury. And by that point, the jury likes you enough, they're not going to like what that expert's doing. So, and to take some risk on cross, which is not easy to do in our cases, right? And to not fight. And this is the one that I wish I could get every young, well, I'll say not young, but less experienced lawyers in MedMal to let go of the literature. So you're not going to win on the literature. I don't care how smart you are. I don't care how many footnotes you have. That's going right over their heads. You're not winning on that. So you have to be creative. So, okay, I'll shut up now. But those are, I'd say, some of the things that we try to bring to the case. So there's a lot of passion, but the passion is behind the scenes.
No, I think that was all perfectly put. I don't want you to shut up. So please, both of you, ramble on, because you guys are dropping a lot of gold right now.
Yeah,
I would love to add something to what Katie just said. So just two things really quickly. Katie made a comment about just being yourself. I'm a big believer in that. You hear all the best trial lawyers say it, but I remember we were at the AAJ convention this past summer, and we got in a couple verdicts last year too. And somebody made a comment to Katie about, man, I really want to see you in trial. I can't imagine how good you are. And Katie was like, I'm just like this. And the person turns to me and goes, no, really, what's she like? I'm like, she's just like this. And it's a great example. I mean, the Katie Bertram that's in trial is the same Katie Bertram that I've been in an Uber ride with, talking with our Uber driver. And I try to be the same thing, right?
Less swearing.
Yeah, less swearing.
I don't swear in court.
I think that that's a big thing. A lot of people don't, they hear it and they think they're doing it, but they don't. You had our good friend Reza Davani on your podcast, Brendan. And Reza, he's a good friend of ours, amazing trial lawyer. He is just himself. I've spent time with him outside of court and I've seen him in court. And he's the same guy. He takes it seriously. He has the same demeanor. He's different than me and he's different from Katie. Katie's different from me and I'm different from Katie. And you do best with the jury. And I think you earn the most credibility when you're just yourself and you don't try to put on a different persona because you think that a certain trial lawyer likes it that way or the jury might like it that way. That's a big part of keeping our credibility. Jerry Spence has a great line about how sad it is that people want to be like him because they give up the most valuable thing they have, which is being themselves. And I'm a believer in that. And the other thing I wanted to just add really quickly was Katie's comment about how we approach cross. Because again, this is something that I think I've learned a lot from Katie and from, Pat Malone and other great trial lawyers, but the idea that you have to be creative and willing to take risks. The best cross exam I've ever seen was one Katie did, not in our recent trial, but we got a $4 million verdict in DC last year in a med mal case. And his expert he was making all of the points, but at one point, Katie was trying to cross-examine him with a package insert. The judge would not allow it, even though she had told us before the cross started that she would allow it. And this expert, who was very savvy, clearly picked up on that while we were having the bench conference. And as soon as we got off the husher, he made a comment about, and your own expert, knowing that he wasn't going to be crossed with this package insert, said, well, your own expert agrees with me because he said ABC. And he just looked so smug at Katie. And I looked over at the jury, and he had scored, air quotes, he scored a point on cross. But the jury just looked at him with this level of kind of like annoyance. And I think it's because Katie remained very simple in her cross, very respectful but assertive. And he was being disrespectful during the jury didn't like that, even though he was, again, scoring points. And it's a great reminder of what Katie just said, that it's not about you as the lawyer. It's about trying to convey truth to the jury. Let them see, pull the mask off a little bit and let them see what these experts and these defense witnesses are really doing. And I feel like the jury picked up on that in a way that was really subtle and in the moment. But it was a great teaching lesson for me because it wasn't Katie scoring a bunch of points. It was her being a fearless cross-examiner, remaining assertive. She did not disrespect the witness. But as soon as he disrespected her, the jury clearly did not like him, and they saw him for what he was. So it's just it's one of those great teaching lessons you only get from witnessing it in the courtroom, but it's a powerful reminder of exactly what Katie and I are talking about and what you've talked about with other guests on your podcast too.
If you
go ahead,
with those experts, you need, I think the biggest skill to being a good trial lawyer is being a good people reader. So ahead of time, you've studied this expert, whether you've taken the deposition or not, and we can talk about my theories on that. But just even on direct, you can read him and you can read what kind of a person he is and how much ego he has. And so on cross, how to bait somebody, you can do it. And when you do it, you're not going to be the star. You're actually going to kind of insulate yourself and be a little more quiet, but his shining horrible traits will come out. And the jury's never going to understand the medicine. They're going to go with a gut reaction. Which of these experts would I rather treat? Which of these experts is bullshitting me? That's all they're doing because they don't get to read anything. They don't know anything. Two people have been paid a lot of money. That's what they're trying to figure out. So all you have to do is show their true character. That's your job on cross. And that's how we do it. And we don't fight with them on literature. In fact, a lot of times, and Kieran had to do this in both trials, we've got stacks of literature and we could, go after them. And that's exactly what they want, because they want on redirect to kick your butt, right? That's what they're going to do. They're going to do it when there's no more cross left. So don't let them do it. Don't go there. And I think it takes a lot of discipline and it's very scary. But once you figure it out and you have a couple successes, that's the way to do it. And we just trash. They're experts, but it's very passive aggressive, right? It's not so direct.
That's awesome. I couldn't agree more with, everything you both said. And I think from the perspective of, being yourself, I've, forever been trying to find that because I feel like I tried so many cases historically where it wasn't so much that I was being somebody else, but like my sort of refined version for me is I'm trying to be the best version of me. Do you know what I mean? And I think sometimes that, when your anxiety's up and, you're freaking out and you're tired and everything, it's just like anything. Sometimes I'm off on a given day with people and I'll regret, oh man, I wasn't like how I would have liked to have interacted with my kids or this person or so forth, because that wasn't really the ideal version of me. And it feels so good sometimes when I think exactly what you're talking about, like you're being sort of like your authentic you, who you're proud of being, not like being somebody else or anything like that. And that's sometimes why I feel like trial can be so special because it's, when you are doing it right, or you kind of are in that right, frame of mind, the zone, yeah, then it feels like so good. And when you're not, which sometimes I'm not, it feels terrible.
Yeah, I mean,
I'm
we
like,
all have
oh,
bad days, right? There are
oh,
days that aren't good. And I don't want to undervalue the pressure, because the pressure in these cases, when you've got a brain injured client or you've got a client who absolutely needs the resources to get experimental treatment, which is what this case was, like he can't quit his job unless we win. Like he's got a year and a half and he won't be able to stop working unless we win so that he can have this money. I mean, so I don't want to undersell that, because that is really hard. And it's hard to just be a normal person standing up there when in the back of your mind, you're like, we have to win. So it's not easy. I mean,
yeah, no. And I don't think that you are underselling it, but I think that's an important distinction to make, that it's like doing all this different stuff while also, in a sense, compartmentalizing that
yes.
pressure that you've got to try to come through for
Yeah.
your client. But
Yeah.
so let's talk about your client. So, Omrell Brown versus medical faculty associates, he seems like a really terrific guy, and reading about him, it sounds like he's extremely musical, and then he's an entrepreneur in the musical realm of DC, and, has this really unfortunate set of medical circumstances, because it really seems like it wasn't one thing. It was like a confluence of medical negligence that came together. So can you tell us, kind of the facts behind, what happened to this poor guy?
He's an engineer by training. And I think there are a lot of people who are both musical and engineering. I have no skills in either.
Not me.
So I don't know. But it seems like it goes together. And his dad was actually a music professor, which is just so cool. So he grew up in this amazing family, and we got to spend some time with his mom, and she's just unbelievable. But so he's going along, just having a wonderful life and giving back to our community and bringing jazz to DC and running the DC Jazz Festival, which is a really big deal, and just a wonderful, artistic, creative, giving person. And also a guy who, despite his really good health, was going to the doctor once a year, which we don't see all the time, right? If you're in your 40s and you don't have anything wrong with you, a lot of guys and gals don't go. And he was going. And unfortunately, they just didn't take it seriously. They didn't take the lump in his chest wall seriously. And as a result, there was a delay in doing any kind of analysis and biopsy, and then the biopsy was misread. And so then you throw COVID in there, and you're talking about a 3-year delay for a guy who otherwise, could have been cured. And so it's just a tragic, tragic case. And one of the things that haunted me is when we did the first focus group, what we noticed when we emphasized how little time he had left, what we noticed is that's a downer for a jury, right? I mean, our job is to call them to action. We want them to feel like everything they're doing is going to help this person or help this family. And if it's too sad, there's nothing they can do. And so what we realized doing that first focus group is, or what I really took home in my heart was, if it's too sad, there's no hope. And if there's no hope, there's no reason to give him resources. They were reaching out. They were saying things like, and it all is all how you do your focus group, but they're reaching out saying, could we give this, could he set up a trust fund? Could he do this? Could he go get experimental treatment? All these things that we can't really argue, right? So I realized we were emphasizing too much of the outcome and not the hope. Like we were not giving them hope. And if they don't have hope, that can't fuel resources. And so we had to back up and, kind of retool what we were asking and how we were presenting it to give them hope. And he was, we didn't have to do much because he's just such a lovely, giving person. One of the things he said on direct when I asked him at the end, we don't do much on damages. We have very, very, very light touch on damages. And I had asked him to think about one or two things that are the hardest for him, and that's all we were going to give. That's it. That's it. And what he said is that he feels selfish when he thinks about, should I go visit my mom or can I take a nap? And he says, I feel so selfish thinking that, that's all you need. No more. Don't overdo. Stop. And because he's such a good person and they just want to help him, we don't need to do anymore. And we don't need to dwell on it because their imagination and those jurors' hearts are way bigger than anything I can do unless I've got Hollywood behind me, right? So in a courtroom, I've got it. I told the story. I introduced him and we gave them a reason to help him.
Is that your approach to damages in general, or is it with cases where the damages kind of speak for themselves? Or do you just generally feel that if you get a couple of those really poignant anecdotes that sort of set the impression of the client, also sort of, open the door to them using their own imagination, like you said, into their life, that's the best approach? Because I don't know, just because. I mean, what's your take on it? Because obviously we can trample on the damages by going into too much specific detail.
Because our job is presenting the facts, and I think two things drive damages: liability, 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 and then bringing out the humanness of your client. And it's not necessarily through your client that you do that. That's it. No, Kieran and I tried a case last year. Awesome young man who was given too much steroids for a gastrointestinal condition, and it basically destroyed his hip joints. So he had to have hip replacements, which was bad. But the jury gave him $4 million. The jury gave him $4 million because they liked him and because the negligence was terrible. And the defendant doctor was awful on cross. And they felt like they needed to honor Mr. Kaplan. And because he was walking around and you couldn't see his injury, one of the big things we like to say in closing is that that's what you're here to do. You're here to give value from members of the community to what he lost and what was taken from him. And that's the most important thing you can do in that jury room. And to me, that's all you need. 2 stories, maybe 3 tops. Very light touch, very light touch. We said for Mr. Kaplan, because he was in his 30s when he lost his hips and he probably has to have them replaced again. But he can work, he can do sports. He can't run the way he wanted to, but well, for most people like me, that's not a loss, right? So the thing that they took from him was his youth. That's what they took, right? Because he's not the same. He's a man with 70-year-old hips when he's in his 30s. So you have to find whatever that nugget is from the client, and that's it. That's all you need. And so we never, ever, ever overdo that 3 years ago, we tried a case, young woman died of an ectopic pregnancy that should have been diagnosed, left 3 little kids, ages 2, 4, and 11. So I videotaped those kids for maybe 7 minutes each. I use it in one of the classes I teach. I asked each of them maybe one question, that they would, not directly, do you miss your mom, but something that the jury would be clear they would have done with their mom, even though their mom was gone. And that was it. Little boy loved to play baseball. He now lives with his aunt. She's very unathletic. I had her tell that story. Like, she doesn't even know how to hold the mitt. She doesn't know where to go. She doesn't, and his mom was really into that, right? So that was it for the little boy. For the little girl, we had her tell, through her aunt, tell the story of having to call when she got her period and not having a mom, And for the littlest girl, it was just a story about getting calming down and having her mom used to read to her in a certain way. That's all you need. We all have experiences that we can imagine what it would be like to lose a parent. I don't have to overdo that for people.
Yeah, listening to you tell that, I'm thinking about this one case where I totally overtried it on the damages part. And but I think the interesting takeaway here is you have to do a lot of work from what you're talking about on the front end to identify, what are those stories, or what are those little, vignettes from their life that, really encapsulate everything and encapsulate the loss and what has been taken from them, which takes a lot of work to discover it. But on the back end is very, it has to be very, almost like gives you peace, because it's less of a weight you have to carry at trial with them, and that they have to, that you don't have to carry the case and win the case yourself. Just tell us about these couple things and how much less, stressful that is for the client.
No, and we tell them that's not their job. Our job is to win the case. We tell them, your job, just answer these questions, and that's all you're doing. You're just introducing the jury to yourself. You're not going to win the case. That's not your job. That's our job. And
how do you approach your? I'm sorry, Kate. I'm trampling all over you.
The other thing is, and I can't remember whose book this is in, so I apologize. This is an older.
We read so many of them. I bet you I can tell. Give it to me. I'm going to try to guess.
Southern gentleman lawyer, like maybe from Atlanta. I'm not sure. He has a great thing about how to prep witnesses for deposition, which we can discuss if we want. But he also talks about going to your client's house, and us going to his mother's house, which, I don't normally do with an adult, right? But here we needed to prep her because we had decided she was the damages witness. Going to her house and listening to her talk about him and his siblings, and that gave me so many good ideas and so much framework that's definitely.
Keenan was always big on, going, making sure you go.
That's who it is. That's who it is.
Keenan was always huge on that. And it is true. You go and you see random pictures that you'd never seen before, you in the house, like just stuff laying around. You're like, well, what's this? Like, oh, I didn't tell you about, this whole thing over here. You discover all these, aspects of their life and what's going on that you never otherwise would have. Real quick, before we get more into the details of the trial, how do you both approach focus groups? So, for example, you talked about, you did the first one in Mr. Brown's case, and you discovered that it was too hopeless, essentially, and you needed to find, like, where's the hope that the jury's going to feel like their verdict's going to matter. So, what was your approach to that focus group? Like, did you do like a clopening, or was it focused on a particular aspect of the case?
I'll let Kieran answer it because he actually managed that focus group. And our real question was actually how much of the future wages to put in. So, which answered that question too.
Yeah. So two things. One person that I don't think we mentioned earlier, who I think has been a big influence for both me and Katie, is Artemis Malikpour, who's David Ball's partner. And we've done a lot of focus group work with her in the past. We did not on this case specifically, but Artemis is a big teacher of too many plaintiff lawyers overstate their damages, right? And it goes back to what Katie said about you're making conclusions for the jury about what they should think about this person's injury, rather than just saying, this is my client, this is their family member, this is their injury, this is their loss. So that's a big part of our whole philosophy about very light touch on damages. And to your point, Brendan, and Katie's point, Artemis has this great like side by side she does of an old woman who is at a Rangers game and she just turned 90 or 100, maybe it was 100, and she's throwing out the first pitch and she's so happy to be there and she's smiling. And Artemis says, "Wouldn't you want to give this lady money?" And then she goes to another clip of a woman in a nursing home who's being interviewed by the local news, and she's just complaining that they're there. She's saying she wants to leave. She doesn't care anymore about anything. And the whole point is people attach to hope when you give them something to hope for. And so one of the things that we found in the focus group, to Katie's point earlier and to our earlier discussion, was this idea that when we made the focus group the damages presentation about this guy would have made X millions of dollars in the future, he had all of this potential, he could have done this, then it becomes this two things. One, it becomes sad for the jury about, well, he's never going to do that. So what are we going to give him the money for now? He's just going to pass away. So what's the point of giving him all that money? He's not married with kids. They're not relying on him for that income. And number two, the other thing we found is the jury then nitpicks all the work that he does. Well, was he really going to make that much? Was he really going to be the next great thing in, jazz and comedy in the DC area? And so it's a great reminder of putting the focus. This is something I've heard you talk about with other guests, Brendan, this idea of put the focus on the defendant's actions and make sure that's driving the case. And then the damages will flow from that. And so I think that's one thing we saw in that first focus group was the idea that by making the damages a bigger focus of the case, the jury awarded less. When we did the second focus group, what we found was by talking about the liability more and by just putting out a very mild vignette of what our client had done and the things that were important to him and what his family had said about him, that resulted in much larger awards. And we didn't even talk about his economic loss. So we were dealing with a future lost wage claim between, I forget the exact numbers, but it was upwards of $7 million. There was a motion made by the defense to preclude that in its totality under the claim that it was speculative. The judge split the baby and said we could put some of it in, but not the full amount. And so we still had millions of dollars we could have put in, but we realized that added two things. One, it acted as a negative anchor for the jury on damages. And two, it created an issue where they were then going to put the focus on our client and nitpick small things about him that they didn't need to, when they were more than happy to award him a lot of damages for the human loss of what he was going through.
Got it. I'm going to hope that didn't get too garbled up because you were dropping a bunch of really good stuff. But let me just understand that a little bit clearer, because I think this is fascinating. So first off, did you not put in your economic loss?
None.
We did not.
Okay.
With the client's permission.
Well, yeah, of course. But that's got to be one of the largest economic losses claims because I'm a big believer in not putting it under the right circumstances. But I would bet you poll, all the trial attorneys, and very, very, very few, like 1% few, are going to be like, oh yeah, we would consider taking out a $7 million economic claim because of what you discovered. That's pretty amazing. Are you seeing that in general? I mean, are there cases where you do put your economics in, or are you generally seeing that is causing more problems than it's creating an upside to your case? Or does it just depend, like everything?
If we're not in a state where we're capped on non-economics, then I'd say almost 100% we don't put them in.
Wow. That's really fascinating.
Here's why, though, and this is a Rodney Drew thing, right? The don't fight in the purple box. In this case, what our gut was telling us is if we put it in, that gives the defense something real to fight on. And that's where, whatever you talk the most about, that's where the jury's going to focus because they think that's where the fight is. And so not putting it in completely stripped that from the defense, right? They couldn't say it was speculative that he was going to do this and that. And I will say, in his honor, he had an amazing career. Like, he was a production manager for Dave Chappelle. I mean, he was bringing it. So he really did have that ability. But it was easy. It's also easy for people to judge. It's a lot easier than judging whether you read the pathology right? We all have opinions about people's jobs and what they should be making, and can they make that in DC, and blah, 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 right? You're now letting the jury sit and nitpick on stuff. That's not your case. That's the defense case. You're in the purple box. You're in the wrong spot, right? Move it back and let them try to argue liability, because their liability sucked. So that's where we want to stay. Do not give them that opportunity. Do not give them that gift. And so, it took a lot to convince the client that was the way to go. And I was scared. I was scared, but because a focus group is a focus group, right? It's not real data that you can can rely on. It's two focus groups. But but it felt right, and it just felt right. So,
and the proof is in the pudding with this verdict.
Well, it worked out, didn't it? It worked out.
Well, so I want to hear more then, okay? Because I'm really getting a very interesting and clear picture on the way that you two are approaching these trials, and I'm loving it. But what was it? Tell me how you approached. And just my read of the X-ray reports is he was in 2018, he was 42 or 40?
43. Yeah.
Okay, 43. So you have a younger guy. No, I'm 47. He's a younger guy.
He's young.
He is a young guy. He's going and seeing his doctor every year. He sees his PCP. He's got a new, unusual lump in his left chest. And the doctor essentially kind of, blows it off. Eventually gets a study done, an X-ray. X-ray says, they recommend follow-up CT scans. She tells him, oh, it's okay. It's nothing to worry about. So now this malignancy is going on because it's actually angiosarcoma. And then to make matters worse, when he finally has the excisional biopsy, the pathologist drops the ball and concludes it's something else, even though I think an earlier read had said somewhat inconclusive, not quite sure what this is. And he should have, then the defendant pathologist should have sent it off to NIH for tumor board review, would have reached the correct conclusion. So now he suffers a double delay. And then when he's finally properly worked up, it's now metastasized. So first off, why was the only defendant that I saw medical faculty associates? Did they employ both of these people?
Yes.
Okay.
So that's the medical group for George Washington University Hospital, which is a big hospital in Washington, D.C. That's where the president would go if he got shot. So it's one of our big teaching hospitals.
So give me your rationale for why do you only name the corporate entity employing them? And then how did you approach the frame of liability and opening to the jury?
So we like to, if we can, not sue the individual physicians and just sue the entity, whether it's the hospital or the medical group, because I think it's a lot easier for jurors to award a full and fair amount against the corporate entity.
No doubt.
Which actually the defense lawyer said in his closing, which I thought was sort of crazy.
What? Said, the only reason they named them was because they think it's going to be easier for you to find against. Yeah. Wow. All right. Well, I give them credit for trying to call it out, I suppose. So walk me through. You do your focus groups. You've gotten a lot of really helpful insight on how to present the damages, which, of course, everything is interconnected at trial. I mean, the damages relate back to the liability and so forth. And, all goes back to credibility. So how do you, walk me through as best you can, how you presented your opening? Did you have a lot of visuals? Was it focused on the actions of the defendants within the corporate entity, predominantly in telling the story? So
one more strategy we had to decide is, do we bring both those claims, right? Because they were very different. The claim against the primary care provider is different time period, different standards, all the different medicine, different facts, right? And then the pathology claim. The pathology claim was kind of nice in the sense that when he finally came back 2 years later, they sent it to NIH. So they sort of proved compared to what, as Rodney would say. So they proved what the standard should have been for us. So that claim we knew was really good. So we were...
And also confirmed that the original slide had showed, in fact, the angiosarcoma.
Exactly. Right? So, I could say to the jury, you've got this paid expert and this paid expert, but you also have NIH, which is very well respected in DC.
And independent.
So that was easy, right? But there was a lot of debate on our team about the claim against the PCP and was it worth it, right? Because legally, it's the first claim. There's still time, right? It's really the second claim that caused the harm. So if you're a lawyer and you're sitting in a conference room, you debate these things, which we debate a lot of things. So, which is good because we need to check out everything. So the second focus group, because I was in the minority, everybody thought that claim sucked. So, and they didn't want me to bring it. And I kept saying, I love informed consent. So I will admit that right away. Like, I am an informed consent queen. So, because here's why. Here's why. We're all patients. We can all judge what we should have been told. And you're able to use hindsight bias to your benefit in an informed consent claim. And so people don't use them and they don't understand those claims, but they are so powerful. And so here, you said it correct, Brendan. The key was the report from the x-ray said you should do a CT or an ultrasound if you want to figure out what. It didn't say should, it said you may want to, right? So we called it a suggestion. Try that in a focus group. Which juror is going to say that they don't want to know that? There's no juror in the world that's going to say that. They can't win. They tried to say it was template language. Now they're just giving me a gift. Now they're inflaming them. Now they look like jerks. It's simple, but easy. So,
why, out of curiosity, why is that a consent claim as opposed to just negligence for not, kind of the standard doctor would have told him everything and they didn't tell him everything?
So consent in the olden days, right, was for a procedure, for a surgery. You tell me if I have it open, if I have a laparoscopic, what I have. That was it. That's not really consent. Nowadays, what consent is informed decision-making, okay? So it's really what you get to do is it's a dialogue between you and the provider about the treatment plan. Okay, so that's how you have to frame it. That's what consent is. So I am supposed to be told as the patient what my options are and what the risks are and what the alternatives are. And then I get to decide if I have that CT scan. You, the doctor, it's not your breast lump. You don't get to decide that. It's my body, my choice. Okay? It works with both liberal jurors, which we have in Washington, D.C., and anti-vaxxers. It works because it's my choice. I get to decide. So it works with both. And it's very, very powerful. But in some jurisdictions, you have to work with the judge in having them understand that it's not just for the choice of a surgery, because that's very old-fashioned thinking. And you have to set that up through your depots by getting the doctor to say, you practice informed decision-making, correct? Yes, that's what we do, shared decision-making. They're never going to say no because it's all over the literature and it's very PC and they're never going to say no. Because if they say no, they're basically doing paternalistic healthcare, which we don't do anymore, right? So it's really easy to set up. And once you get those steps in a deposition or you get their informed consent procedure and policy, you've got it because it's in every patient rights publication too. So all the hospitals say that you have a right to know your care, to know your diagnosis, to know your treatment plan, to make decisions, active decisions about your treatment plan. That's the new informed consent.
So I'm getting the sense that you did proceed on this claim as well as the pathology claim.
Yes.
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 Yeah, we found from the focus group, the second focus group, they were more upset by the claim against the primary care physician for the lack of informed consent. And I kind of came to appreciate the power of informed consent before I started working with Katie. I heard Keith Mitnick talking once about medical malpractice cases, and he made a comment about you always want to get your expert to both say that the failure to act was negligent, but it was also negligent not to offer the other option to the patient. And as a med mal lawyer, I thought, well, that's a lack of informed consent claim. But he found when he talked to jurors and doing med mal cases, he's obviously the preeminent trial lawyer in the country, right? And he heard from a lot of jurors, they would say, I felt bad criticizing that doctor for not doing it, but by golly, you got to at least tell the patient it's an option. And that's when it's like it first clicked in my head about the power of informed consent. And so in our case, the issue was the doctor claimed that she did tell Omrau about the suggestion for the focused ultrasound or CT, but she claimed that she sent it in his patient portal. So during cross-examination, Katie had me handle the primary care claim. So I cross-examined the defendant doctor when she was put up. Very nice older woman. She had recently retired. She's not the type of person that a young male lawyer like me should be going full bore at, right? And the jury would absolutely hate me.
Smart man, Kieran.
But what I realized was she had kept talking about how she sent this in the patient portal. And I think the defense thought, well, that's enough. Like, we're covered, right? She said she sent it in the patient portal. But we had some versions of patient portal messages that had been sent in the record, but not that one. And we also had a PDF, right? This is like just knowing technology at a base level. We had a PDF of a letter that was purportedly sent to him, but she admitted she would not have sent it in the mail. So during cross-exam, I pulled his most recent patient portal messages where he was trying to reach out to her once he found out about the cancer and was trying to get appointments made to see a surgeon and get another consult. And she wasn't responding. So I showed her those and I said, you indicated you communicated with Mr. Brown via patient portal message. Is that right? Yes. And I said, do you consider that to be part of the emails you sent with him? Because there were emails in the medical records, right? Gmail account to MFA account, right? So clearly emails. And she's like, well, no, I think those are patient portal messages, right? We have very young jurors in DC. And I just said very nicely, just so the jury understands, do you think an email is the same as a patient portal message? She said, yes. I said, okay. I then showed her the PDF document, which she claims is the notice she gave. I said, okay, this is the letter. This is the PDF document. Correct? Correct. Do you know how this was sent to Mr. Brown? She's like, well, that's it. And I said, do you think a PDF document being uploaded to his chart is the same as sending him a patient portal message? And she's like, yes, I think they're all the same, right? I mean, she clearly doesn't understand how to send these. She testified at her demo. She struggled. So the cross was not some overbearing 30-minute cross about how bad she was. It was just 15 minutes of me showing she did not understand the EMR and how to convey information directly to the patient through the EMR. So then that last thing I showed was the most recent patient portal messages that our client got for us, where he's reaching out, she's not responding. And I said, why didn't you respond to these if you communicated via the patient portal? She said, well, I'd never seen these before, right? And that was it. So then the jury gets it. I don't need to beat her up about whether she thinks the patient has a right to know where it was negligent. It's just showing that. And then the other problem, to Katie's point, she claimed this was just a template. This is on all the x-rays we do, yada, yada. And so before I did her cross, I went back through all the records and I found that there was another x-ray done 2 years before. And lo and behold, there's no recommendation for a focused ultrasound or a CT. So I asked her, you indicated to the jury that this is a template. This comes on all the imaging studies. She said, well, maybe not all the imaging, but on the x-rays. So I asked our tech to pull up the x-ray from a year and a half before. And I said, this doesn't have any suggestion, does it? Well, no, it doesn't seem to be on there. And I said, it does have your handwriting where you said called patient to notify him, right? She's like, yeah, it looks like my handwriting. I said, because that's how you communicated with him. You called him normally, right? But you didn't call him about this focus. And so it's just kind of putting all those little pieces together to show like a good doctor would do. If they need to call their patient, they do. She just chose not to call him on this one occasion. And whether she did or did not actually think she uploaded it, is something we'll never know. We think that the defense may have sort of maybe come up with that as a defense on the back end. I'm not suggesting she perjured herself. It did not feel like it was an accurate reflection of anything she did with this patient. But it was easy for us, instead of trying to beat her up, to just show the jury, this is somebody who, very nice, older female doctor, but she doesn't know how to do the things she's claimed she did with this patient.
But it also got us, we could get in those late messages that she never responded to, right? Because those are subsequent bad acts that we normally wouldn't be able to get into, right? So it allowed Kieran to open the door, and that's a Mark Mandel, I can't get over it, bad fact, right? He's begging her to get this MRI of the tumor in his abdomen for a month, and she's not responding. So it gives the jury a flavor for what's going on. And then also Kieran bringing up the other one where she's got her handwriting and calling the patient, telling the patient the normal result. Again, that's us setting the standard of care through her. Impossible to cross her or to redirect her on that. So those are things that I think are gold, but you have to know the record, right? Backwards and forwards. And that's our job. So you have to be ready with things like that they can't turn on you.
That's awesome. Kieran, what were you going to say?
I want to just add one thing, because we're talking a little bit about the directs and crosses now, but before we move off of the opening, Katie gave a phenomenal opening, and Katie's openings are, and this is the format I have adopted as well, is simple story, narrative format. She does not list through witnesses. She doesn't use the PowerPoint as a teleprompter, and that's something we've seen a lot of our defense colleagues, very good trial lawyers, incredibly impressive, but they turn their opening and closing PowerPoint slides into teleprompters. And they're just reading text off the PowerPoint slides to the jury. And I think it was Rahul Ravi Pudi talk about the use of PowerPoints and how the most effective thing is to have an image either coupled with brief text, or for you to be talking while there's an image up, that our brains process that more effectively. And so Katie and I are big believers in using visuals. We'll have some text here and there. I'm not suggesting we don't. But to have just a simple story, not listing out your experts and their credentials. It was a narrative story, simple, right? One noun, one verb, maybe, an object of, but it's just very simple sentence structures, very simple story. And it was just very compelling. Nothing over the top, no making conclusions for the jury, just, this is what we'll see. This happened to the patient. And so I just wanted to highlight that, because I do still see a lot of colleagues who will do that sort of lots of words on a PowerPoint and or hyping up their experts. Like, that's not what's going to, I don't think, win the day for us. It might for the defense sometimes, but I think what wins the case for us more often than not is structuring and framing a simple story that jurors can relate to and understand. And Katie does a phenomenal job of that.
Yeah, and I think you can teach them a little bit of the medicine in the opening,
Yes.
but not overboard. Because I think also our MedMel colleagues, we feel good and proud that we've learned all the medicine we have, but you can't do that in the opening. The defense lawyers always do it way too much, and it's super boring. So I don't think that's necessary. We do use like a really basic calendar sometimes to show
timelines
how
and so
long
forth.
things took, or how, but I mean, super simple calendar with like little symbols on it that we often, Kieran has helped me do better with this. Symbols that you'd get on your iPhone, if it was an email, we show that. If it was a text message, we show the little Apple symbol. So, trying to use things that they're familiar with, but trying to give them perspective and context. And I think that's really important. But telling the story from the defendant's standpoint, from the liability standpoint, is very important. And here we were also lucky because I hadn't anticipated how much the defense was going to go hard saying that this pathologist didn't misdiagnose it. And when we finished openings, I said in the Uber on the way back to the hotel, that gift is a huge gift, and it's going to keep on giving, because they can't win that. Like, that is not how to defend this case. And they did it over and over again. And it was, I think, I mean, I'd like to give us credit, but I think they helped us quite a bit.
But that's the magic of trial sometimes, right? Like you get these kind of inadvertent gifts just because you got to trial and you never could have expected that of all the things they're going to be defending is the pathology interpretation.
But I do think that's because we didn't tell them until the day of trial that we were not pursuing the lost wages or the huge medical bills that he had. He had almost $1 million in medical bills too.
Because they're ready to just pounce on fighting all that stuff, and now you took it away from them.
We see, we get a very, very educated jury. You don't get anybody. Most people have at least a college degree. Many times you have people with advanced degrees, which is exactly what this jury was. So they know everybody has health insurance. So it's not a hill to die on. So we don't put in those numbers, but taking all that away meant the jury, the defense had to fight somewhere. And where do we have them fighting? Exactly where we want them, on liability.
So you structure your opening, predominantly through a defense-oriented story. What are your first few lines? And I ask that because I'm experimenting lately. I'm trying to always kind of change things. And my most recent trial, I'd never done this before. I did this is a case about, and summarized the case in one sentence. And then transition. Oh, did I strike a chord here?
Yeah.
What do you do?
I do the 3 simple rules.
Okay. So give me an example.
I will say that Pat Malone would probably give me a C for making sure that I had gotten everyone to agree on these rules during discovery, because I don't know that I did really. But because we weren't sure whether we were bringing that claim or not. But so the rules we put up were, the patient has the right to make choices about their own health care, right? And what were my other rules?
So you did a mix of rules and principles, right? So if you read Rules of the Road, it's like rules versus principles. But
sure,
it was a mix. So it was early detection saves lives.
That's right.
Rare, I think it was rare means more care.
Rare means more care. Yeah.
You're concerned about a rare aggressive disease.
Yeah.
Oh, and worst first. You talked about the fact that the doctor, we did not appreciate this until we were going through and designating. Katie and I like to videotape all of the depositions and play them in our own case in chief, because by the time trial comes around, they're polished, they're ready to look nice. So if you call them, a lot of really good plaintiff lawyers will call the defendant doctor first in their case and try to grill them. They're way too polished and prepped. So it works sometimes, but we think it's more effective. Do it at the depot. They're not smiling as much. They don't dress up as nice. They're not as prepared. This doctor had said several times, we did not appreciate how much he went on a limb, that he had ruled out everything except angiosarcoma, which is really aggressive, right? Rare, but aggressive, but he acknowledged he considered it and thought it was possible. And a glomeangioma, which is a really small, essentially it's like a vascular lesion, but it usually is around under your fingernails. It has to do with your limbs shunting blood away, And so he had ruled out everything except those two, but then he just said, well, it's a glomeangioma, even though other people raised concerns. So Katie used that for one of the rules of worst first. If you're considering it, you have to make sure you've ruled it out. And then the one that Katie always does a good job of, which I've totally stolen from her, is just every patient has a right to make fully informed decisions about their treatment plan and about their body. And I just think that resonates with jurors. So we very often will open with that statement as our first line. Every patient has a right to make fully informed decisions about their body and about their treatment plan. And that's usually the go-to. And then it's whatever other rules or principles follow off of that. So those were the 3 or 4 that Katie went through at the beginning before then getting into the narrative, addressing the defenses, not giving credit to the defense, but saying we had to investigate and consider these.
Right.
One slide on damages, right? We have one slide we use for damages in all our cases, just to say, last thing you'll have to talk about in deliberations, we'll get to it later, is damages. And that's it.
So I think there's sort of 2 schools of thought, at least so far as I can tell in talking with different trial lawyers about the use of rules. So I think no matter what, a rule is always a frame in one part. Like that's the starting lens you're giving this jury to now see the facts of the case. And now they're going to be able to kind of put 2 and 2 together by listening to your story. And they're going to reach, hopefully, the conclusion themselves. some people leave it at that. And I've done kind of a mix. In some trials, I'm very heavy throughout the trial and kind of going back to the rule. Others, I hit it in an opening, I talk about an end and closing, but I really didn't make it all that central of an issue during the proof part of the case. How did you find yourselves through your medical witness or anybody else coming back to those, or was it mostly just the lens to frame the case, and now you're just kind of, the jury gets it and you're getting more, just into the basic opinions and so forth with
more
everybody?
the latter. And I think
Okay.
it's almost a vehicle of trust too. When you start out like that with things that are pretty irrefutable, the jury's like, okay, she's not a snake oil salesperson. She's just saying stuff that's pretty basic. And if that's what she's talking about, I can get away, I can get on with that. Like, that's right. And that should be what happens, And then, so I think it's a way of opening that people can relate to, and then trying to tell a compelling story, but telling it from the standpoint of the decision makers who made the wrong choices. And so I think a lot of that is a combination of David Ball and Artemis, and then Mark Mandel, because the story in the end is do your job, right? And if you don't know the answer, ask someone else. So those were the things we had in the back of our minds that we don't say until the closing, right?
Yeah, so you held that back, the big critical framing theme to the closing.
And
Gotcha.
and I just think those you can develop such good Mark Mandel, I can't get over it facts by doing those focus groups. I mean, they just give you gold. And we really do pull a lot of stuff out of those groups and try to make sure we bring those facts out, to the point where, in this case, the defense lawyer stood up, not in the presence of the jury, and was like, Your Honor, Ms. Bertram's just trying to bring out all these bad facts. She's just trying to trash my client. Da, 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 da. The judge is like, those facts are true. Like,
yeah, right. Sorry, those are the facts.
Sorry, y'all did that, but that I can't stop her from actually using the facts in the case. You know? So I love it when they start saying I'm a witch. But it
means you're doing a good job.
But I mean, it's those things that give the vibe that you need to give the jury permission to make a really big decision, right? They're basically saying, I mean, I would never say this to them, although the defense sort of did. You're saying that this pathologist killed this patient. I mean, that is what you're saying. So that's why the liability drives it. That's why it has to be right. That's why you have to show all the senseless, needless errors and choices they made, because it builds. And when it builds to the conclusion that you're empowering the jury to do. And to me, that's our job. And it's the best job in the world, but
it is.
That's our job.
So walk me through that now. So, you've talked about all these different, I can't get over, the debates both on the damages, the debates on, the liability theories, the forward. Case goes well. Defense now starts making arguments that are very disingenuous, probably only going to serve to help your case. So talk to me about your approach to closing. And then, looking back in sum and substance, what do you think it was that really drove this verdict? Because, it's an exceptional verdict. I know it's a horrible story and there are terrible facts, but I mean, what was it in your opinion?
In my opinion, it was the disorganization of the medical practice. For example, the primary care doctor that Kieran crossed, guess how many patients she had assigned to her?
I can only imagine. What, like
2,000.
How many?
2,000.
Oh my God, yeah. That's a lot more than I was
That's one of the slides in closing, right? And words matter. So we try to own like the 10 most important words in the case. Okay. Chest wall versus breast lump. Which one do you think we want to call it?
Mm-hmm. Right.
Breast lump. Men have breasts. I mean, I must have said that 10 times in the case. Pointing to his nipple, pointing to where this was. It wasn't in his chest. It was in his breast. No one should have a breast lump. So it's learning those little things that you can see, like when Kieran asked the questions about the note, that sounded sort of dry, right? You're asking about patient portals and PDFs, but you watch, they're writing it down. That they can judge, right? This guy never got this message. They let 2 jurors on whose fathers were radiologists. How do
Oh,
you think
wow.
it goes over if you say that's just boilerplate language? So, I mean, and there were 2 engineers on the jury. So we made sure when we talked about we haven't talked about this yet, but the size of the tumor, that we talked about volume and calculating volume, because engineers can do that, right? And they understand that growth isn't just in centimeters. So, thinking that through and staying present and being nimble in trial with each witness and each direct and each thing that happens, I think is really key. So, yeah, do we have it planned out? Sure. Do we change it every moment? Yes. Yes. I mean, maybe this is bad. I don't write my my closing. I
I was going to say, you don't write your opening. Wow.
I kind of don't write my opening either, but don't tell. So, but the closing can't come together for me.
Sure.
I know
Yeah.
people say you should do it 6 months in advance.
No, that's
Bullshit.
ridiculous.
Like, I
That is
don't do
totally
that.
ridiculous.
I
Yeah.
don't do that, because how do you know? And I think this is not a criticism, because we have some of the best defense lawyers in the world here in DC, and they can kick my rear end. So I'm not criticizing anybody. But what you see sometimes is, and not just this case, I'm not saying it was this case, they're locked in, man. They've got folders, they've got cross, they've got this, they've got that. And they have so many cases. They don't have the luxury of spending the time we do on these cases. So they're going to ask those 20 questions, whether it's relevant today or not.
Yeah, right.
So the advantage you have is your creativity. The advantage you have is being able to devote every waking moment to Mr. Brown, because you only have 4 other cases that you're responsible for. So, I mean, for me, that's why I do this side. Like, that's what I love. And that's really important. So I think it is that slow build or that slow burn throughout the case of making sure that all these little nuggets are clear to the jury so that they have permission to do what they need to do. And then when they get there, knowing that they really feel for your client and that they think he's a very good person and that they know this money could be used for him to quit his job so that he can go wherever in the world he needs to go to get whatever he can get to try to extend his life. But more than that, to put a value on what they took. And what they took is 25 years of his life. He's not going to have that. What they took is, changing every relationship he has. Every waking moment he thinks about, is it selfish for me to take a nap? He couldn't get married. He testified to that. He decided not to get married and have children because it would be selfish. So, I mean, when you say those kinds of things, and then we use this iceberg photo for these kinds of damages because they're hidden, that they see him in the hall, walking down the hall, and you don't know his loss. You don't understand what he's going through, but the 8 of you do. And this is his one shot. And this is his one chance for this community to give him an award that values what he lost, because nobody else can. And that's what we do. And we're not allowed to give specific numbers in DC.
I was just going to ask you that. You're not. So you can't make a suggestion to them.
So
because that's how Pennsylvania is. I thought we were like
we have a case called Colston, and all I can do is follow Colston. And so you can say, some of you might think, you have to say, ladies and gentlemen, it's not up to me to decide what this case is worth. It's up to you. It's up to your collective wisdom. Some of you may think it's worth X. Some of you may think it's worth Y. It's completely up to you.
You can do that.
Yes.
Okay, that's better than Pennsylvania. So what was it Colston? Is that the case?
Colston, yeah.
Sorry, so give me your Colston numbers.
So I did 20 and 28.
Why did you do those numbers?
Truth be told, I wanted to make sure that if they cut it in half, I did better than the last offer. That was the 20. And the 28 was his life expectancy. But I had a real feeling that it was going to have something to do with 25 because he was going to live another couple years. So if
important anchor number.
Yeah. So I think that's what they did. I don't know that. I mean, we'll never know. But
did the focus groups give you any sense of the value of the case they were attributing?
They did, but they weren't that high.
They weren't that high.
Wait, and just because I didn't want, I don't want to bury the lead there. Was there an offer of $20 million?
No. I said I want to make sure I doubled more than doubled it in case they cut it in half.
Okay. Oh, okay. I was like, whoa, you guys are real beasts.
But in the middle of trial, the offer was such that.
Yeah, a lot.
It scared the living, out of me to.
I bet.
Take it.
Yeah, that's amazing. That's awesome. How long did they deliberate for?
5.5. Is that right, Kieran?
Yeah, 5. It was just a little over 5 hours. Yeah.
And so it would have been a past and future non-economic verdict, right? Yeah. And how did that break out?
We asked for
one line. Yeah.
Oh, just one line for everything.
Yes.
Yeah, the defense can demand that you break it up, and then you have to under the case law.
Now, why did you want one line?
I was worried that if we broke it up, I was worried that they would limit the numbers, that it would make them focus too much on his limited life expectancy.
Okay. All right.
So I decided for them that it might be easier to come to a number if they could just come to a number, which is opposite of what we did in our last case. We split it up on purpose because we wanted them to focus on the kinds of harms and losses he had. So I think it depends on the case.
Yeah. I mean, I think that's the awesome takeaway from the both of you. You've proven extremely thoughtful in the way that you think through everything on these cases, which was how Kieran described, what he learned from everything from the beginning is detail oriented. And you clearly were detailed oriented about every aspect of the case, even down to how many, which is the preferred number of lines for the verdict. And so what was, I think you mentioned it, what was the ultimate verdict?
Oh, 25 million.
And how did that hit your client? I mean, he must have been overwhelmed.
I will say, having done this for 35 years, that that was up there. That was one of the most rewarding moments of my life.
Yeah, I can only imagine what it was like being there.
Crying, and how tall is he, Kieran?
He's probably like 6'4", 6'5", very tall.
Oh, big guy.
6 feet. So and to get a hug from him like that and have him just bawl was in a relieved sort of way was something I will never, ever, ever forget. And we didn't have him sit through a lot of the trial because he wants to keep his hope. And I explained that to the jury in the opening. But I'd say he sat through maybe 20%, right?
Yeah.
We couldn't have him in there for a lot of it. So I was just so glad that was some closure for him. Because I think having to see those doctors take the stand and say the things they said, I really didn't want him to have to go through that. So, and putting his mom on the stand, I think, was the hardest thing he had ever done. We didn't let him watch it, but just knowing she was talking about caring for him after the surgery was hard for him. So I will say that, that, and I also have to say this, and if you cut it out, you can cut it out.
Please. No, I will not.
I am so proud of the job that Kieran did. He took on one of the most notorious defense oncology experts that we all see all the time, and he shredded him. And I just have never been more professionally proud. So I just have to say that too.
Kieran, I'm sorry, I'm cutting that. No, no, that's such a nice. No, A, that's awesome, and B, that's really sweet, and it's been great talking with you both about this case. And congratulations to the two of you. Clearly, Mr. Brown deserved it. You know, you earned it with all of your hard work and efforts and trusting in what you were learning from the focus groups and your gut and everything. It's really way surpassed what I was expecting to learn about this case. And it's really inspiring to listen to what you two put into this case and the outcome that you got. So, you know, Katie Bertram, Kieran Murphy, congratulations. Thanks for talking with me about this case. This was, I learned a ton today, and I know that the listeners will as well. So thanks for doing this.
But also thanks for what you do, because you take the time out of your practice to do this. And I'm sure it's costly too, because you've got an amazing production team and all this equipment. And frankly, one of the ways that we get better and one of the ways that we try to do best for our clients is by listening to things like this and to your podcast and, you know, staying current and trying to always redo and retool to make it better. So thank you for all the time you devote to this as well.
Hey, thanks for saying that. But honestly, it's largely a selfish endeavor because I get so much out of it. Like, I just listening to the two of you talk about it and the way that you explain it, and with so many of the other people that I've gotten to speak with, I learned so much. So it pays for itself just in that and getting to meet awesome people like both of you. But thanks for saying that, Katie. I appreciate it. So I have taken up so much of your time, and you guys have been so gracious, and we put up with a rainstorm and power outage and technical difficulties and multiple starts, and it was all worth it because this was a terrific time speaking with both of you. So I look forward to seeing and meeting you guys in person one of these days. I'll see you back on the ATLMG listserv, and you two both keep kicking butt. Congratulations again, and thanks for doing this.
Thanks, Brendan.
If you enjoy the show, please subscribe to the Just Verdicts podcast on your favorite platform and consider leaving a review. And if you're interested in co-counseling, local counseling, or referring a catastrophic injury case, we'd love to work with you. Call us at 412-281-4100 or visit our attorney referral page at pamedmal.com/refer. Thanks for listening.